Many expats and foreign investors assume that once a will is validly drafted abroad it will be automatically enforced in Vietnam. This assumption is risky. Enforceability in Vietnam requires deliberate legal steps. A will may be valid under the law of the country where it was signed. But enforceability in Vietnam depends on compliance with Vietnamese inheritance law and procedural requirements. These are separate legal tests. Step 1. Confirm formal validity under foreign law. The first step is confirming that the will was properly executed under the law of the relevant foreign jurisdiction. This includes signature requirements, witnesses, notarization, and testamentary capacity. Vietnamese authorities will examine whether the document was legally formed at its origin. Step 2. Legalization or apostille. Before a foreign will can be used in Vietnam, it must be legalized. In most cases, the will must undergo consular legalization under Vietnamese regulations, unless an applicable bilateral treaty provides exemption. Without this step, the document may not be accepted for probate proceedings in Vietnam. Step 3. Certified Vietnamese translation. All foreign language documents submitted in Vietnam must be translated into Vietnamese by a certified translator. Translation accuracy is not administrative formality. Errors in wording can materially affect interpretation of inheritance provisions. Step 4. Review substantive compliance with Vietnamese law. Even a properly legalized will may contain provisions inconsistent with Vietnamese mandatory inheritance rules. Vietnam recognizes certain protected heirs under forced heirship principles. If the will excludes individuals entitled to a compulsory share, challenges may arise. Minor children, dependent heirs, and certain close relatives may have statutory rights. A foreign will that completely disinherits protected heirs may not be fully enforceable in Vietnam. Advance review allows risk mitigation. Step 5. Identify the type of assets in Vietnam. Real estate in Vietnam is governed primarily by Vietnamese law. Movable assets such as bank accounts or shares require separate conflict of law analysis. Asset classification influences enforceability strategy. If the estate includes land use rights or property in Vietnam, local probate procedures are unavoidable. Foreign probate decisions alone are insufficient. Vietnamese authorities must recognize or process the transfer domestically. Step 6. Initiate probate or notarial procedure in Vietnam. Heirs must initiate formal inheritance procedures in Vietnam. This may involve notarization of inheritance declarations or court proceedings if disputes exist. Foreign wills are reviewed within this process. Step 7. Prepare supporting documentation. Authorities typically require death certificates, identity documents, proof of relationship, and asset ownership evidence. Missing documentation is one of the most common causes of delay. Cross-border estates demand meticulous preparation. Step 8. Address potential dispute early. If there is a risk of contested inheritance, proactive negotiation may prevent litigation. Vietnamese courts examine fairness, consent, and statutory compliance closely. Early legal strategy reduces uncertainty. Common mistake 1. Assuming foreign probate is enough. Many families believe that a foreign court order automatically authorizes asset transfer in Vietnam. In practice, Vietnamese authorities require separate domestic procedures. Recognition is not automatic. Common mistake 2. Ignoring local advice until after death. Estate planning is often reviewed only after the testator has passed away. At that point, structural defects cannot be corrected. Preventive review while alive offers far greater flexibility. Should you execute a separate Vietnamese will? For individuals with substantial assets in Vietnam, a parallel Vietnamese will is often advisable. This does not replace the foreign will, it complements it and simplifies enforcement. Multiple wills must be carefully coordinated to avoid unintended revocation. Conflicting clauses can invalidate strategic intent. Professional drafting ensures alignment across jurisdictions. Inheritance involving foreign elements may trigger reporting obligations. Heirs must comply with Vietnamese tax and administrative procedures. Non-compliance can delay asset transfer. Making a foreign will enforceable in Vietnam is a structured process. Each procedural step creates legal certainty. Skipping steps increases litigation risk. If you own assets in Vietnam and rely on a foreign will, do not assume recognition. Conduct a cross-border estate review proactively. Legal coordination is significantly less costly than post-death dispute resolution. Foreign wills can be enforced in Vietnam, but enforceability depends on legalization, translation, substantive compliance, and proper probate procedure. For multinational families, planning ahead transforms complexity into control. If you own assets in Vietnam and rely on a foreign will, do not assume enforceability without review. Under Vietnamese law, recognition depends on structure, localization, and procedural compliance. To assess whether your foreign will can be effectively enforced in Vietnam, contact LTS LAW at lts.com.vn for confidential legal guidance tailored to your cross-border estate plan. Structure first, certainty follows.